filing fees. Thank you, Sandy. So we're being recorded. We were talking about filing fees, and there are two larger issues relating to filing fees. And Jim has provided, is Jim on the line? I haven't seen him yet. But Jim has provided two memos. One is about the filing fees. And there's two issues. One is what types of cases should have filing fees. So we have violations, and then we have misdemeanors or state crimes. That's one issue. And then another issue is what fees should be assessed. So you could have a filing fee, you could have a trial fee. So those are things we were talking about last time. We did think it would be helpful to have a little more information for our discussion, and that included information about how many of these appeals are really coming from the justice and municipal courts to the circuit court, because one of the things we were talking about was it could be administratively easier if we didn't have these fees and have to figure out what qualified as a violation and a misdemeanor. But we needed a better sense of, you know, how many of these cases there were, what were we collecting in terms of fees. And I think Lindsay looked into that and has some information on just the numbers that maybe you could share with us.
Yeah, I will. I'm sorry I didn't get that out to everyone. I sent it earlier this morning. I'll send it to the group right now. I have a spreadsheet. I'll put in an email.
So Lindsay's gathered some numerical information for us, and that was part of what we'd asked her to do. And the other part of what we'd asked her to do was to think about what a process for, if we have these fees, what a process would look like when you file the notice of appeal, but you want a fee waiver. And I know she's working on that and talking to folks at OJD on behalf of the circuit courts, which are the courts that are receiving these appeals. And that's in the works. And so Lindsay, right, we're going to talk about that at our next meeting, but I just wanted to circle back and say that's underway. And so that's where we are on fees. And I'm going to look at the email. Lindsay and Steve. Is there a way to just share the screen, Lindsay, if you have it called up?
I can give whoever needs it the access.
Or it might, Lindsay, if there's just a kind of raw number that you think would help us.
Sure, I just sent you all. Okay. I think hopefully it went through. But yeah, I can give you a little bit of information on the raw numbers. So the fees in these cases, first of all, there aren't very many of them. And so the fees are not that high. So let's see, for fiscal year 2023, the total amount of filing and trial fees collected was $17,000. Fiscal year 2022, it was $19,656. And it hovers about the $20,000 range. And then we also have, there's a sheet in here about with the numbers of applications for fee waivers and the orders granting fee waivers or deferrals.
So maybe we can take this information, think about what the numbers and dollar amounts mean, you know, what we think about those and how they affect whether we keep the fees and whether they're applied to both types of cases we've been talking about. Now, Lindsay, my computer's screening the attachments still, so I can't look at it. But are these, does this information cover both criminal or violation cases and civil cases?
Yes,
okay.
It does. So it's organized by, that's so odd that it's screening. It's organized by court, by circuit court, and then which local court that the cases come from, and then by criminal case types, and then civil cases.
Okay. So has anyone thought about more the issue of fees and want to share information or thoughts with Lindsay? I know she's still working on the process and running that through OJD, but with this information or just in the time that you've had to think about it since our last meeting, does anyone have anything they want to share about whether the fees should be collected in violation cases? And then I know from the feedback we got from Judge Brisbane on behalf of the local courts, there was a thinking that even if we are going to keep the fees for the violation cases, it would only be the filing fee, and the recommendation was to not require the trial fee. Is that my understanding? I'm seeing a lot of nodding. Great. Okay. So I just want to see if anybody has any thoughts on that before we, leave it with Lindsay to continue to make recommendations regarding a proposal for how to handle the fee processing.
The only thought I had is part of what we're trying to accomplish here is to simplify the statutory scheme, and having filing fees and or trial fees due in violation cases, but not in misdemeanor cases, to me adds another layer of unnecessary complexity.
Okay.
And I would favor eliminating the filing fee for violation cases as well as misdemeanor cases.
I think that makes sense.
I do think if you eliminate the filing fee, you're going to see a lot more violations appealed. That is we can debate whether or not that we care about that, but that's the fact of the matter is if there's zero cost to appeal it, you'll get a lot more appeals that will be filed.
So then are we talking about using the filing fee as a barrier to the appeal system?
Well, I'm talking about it in terms of how the reaction of the circuit court, how the circuit court may feel about that. And I think it's probably important to get their thoughts and input with regard to that, especially if we ultimately may have a bill at some point that we're going to want them to support.
Well, it's already been established that this right to appeal exists, so I don't think it's really within the purview of this work group to decide whether or not people exercising that right would be something that would be desirable or not.
I don't think I got that. I'm so sorry.
I'm sorry, can people hear me? My microphone is like notoriously terrible, so I'll move closer.
I could hear you. I I just didn't quite make the connection, and I apologize.
Well, I think insofar as we're considering whether eliminating the filing fee would affect the rates of filings, the legislature already determined, and I don't think we're revisiting whether people would have this right to appeal. And so, we're not really determining whether or not people appealing is a good or a bad thing. That right of appeal exists. And in any event, I think more access would be, if I was going to opine on this, I would think more access would be a positive thing. But I don't think that we're attempting to deter people from filing where they have a right to do so.
And I think, go ahead.
I was just gonna say, if I remember right, the legislature has made a determination on this, on violations, both this kind of appeal and also violation appeals to the Court of Appeals. And the legislature has determined that it is proper to impose a fee on violation appeals. I think in part because of the judicial resources that holding multiple trials over that kind of thing can encourage, right? So they've already made a determination. What we would be doing is suggesting that they change part of that determination here, but not for the circuit court appeal, or not for the appellate court appeals.
If I can clarify, I don't mean to say that the legislature hadn't made a determination about the filing fee, like, that's what we're considering, but whether those appeals should be permitted or encouraged or discouraged or deterred. I don't think that that's the purpose of the filing fee. It would be to cover administrative costs and that kind of thing. And so that's where this data is really useful. And I haven't had the chance to really look at as a practical matter what it's meant for revenue. It'll be helpful to see that.
And that's all I'm talking about, by the way, is the circuit court. If we were to submit a bill removing the filing fees, which would, in my opinion, result in a lot more appeals and violation cases, then the circuit court is going to have to deal with those, and without any input or thought or participation, they may well not think that's such a good idea, and they may not support the bill, and that may hurt our chances of getting it passed. I don't know if that would be the case, but I think we would sure like to know the answers to that.
And I'll add from the circuit court's perspective, I think there would be an indeterminate fiscal impact because we can't quantify the increased number of violation appeals at this point. So we can't, tell prospectively how many more people might file these cases. So as far as the policy question, I don't think the circuit court and OJD has a position on the policy question of whether or not there should be a fee or its amount. But when it comes to the bill, there would be an indeterminate fiscal impact that we'd have to assess after the fact.
Well, for example, on your chart, you may notice from my court in Washington County over the period of time that's on your chart, only 5 violations were appealed.
And as far as the fiscal impact goes, I don't think, again, I haven't accessed the spreadsheet, but we don't know which cases the waivers are in. And so we don't know if there is actually, if in the violation cases, the fees are actually in the end being paid or whether they're being waived.
Anecdotally, from my court, the FEDs are very, very likely to get a waiver, and the people who come for violations are much less likely to get a waiver just because of the nature of the cases that they are.
And I saw hands, Krista and Jordan.
I was going to, I think, make the same point that you just did, that I was wondering if there was any data on how many fees are getting waived. And so that, we have any idea of what, whether or not this is really a deterrent. I mean, are most people qualifying for waivers anyway?
And Jordan, I saw your hand, and then I saw Heather's hand.
Thanks, Justice. I was just going to say, I think we need to figure out what we're talking about here, because if we're talking about assessing a fee to cover an administrative cost that the court has, I think that's a very different question from if we're talking about putting a fee in place because we're worried about the increased number of people accessing the court system, which sounds an awful lot to me like putting a barrier in place to stop poor people from accessing justice. And I am happy to take that fight up with the circuit court if they decide to oppose the bill because of that. And I don't think that's a position that they would take. And Lindsay's shaking her head, and I'm not sure if that's because she agrees with me or not, but I don't think that's a tenable position for them to take, to say we need these fees in place because otherwise there are going to be a whole lot of people trying to access our court system.
Exactly. Like I said, we obviously encourage access to justice and wouldn't take a policy position either way that would discourage that. It really just has to do with the fiscal impact on the department. And from the numbers that I have, it looks like, so fiscal year 2023, there was a total of 103 of all of the types of appeals from local courts. There were 15 applications for fee waivers and 15 were granted. So it's a fraction of the total number of appeals that are filed.
And then we'll maybe wrap up with Heather on this point because we're still gonna go to Lindsay's gonna be working on a process. So Heather, and then I'll have one more comment and then we'll move on.
I had a question for Lindsay about the data. I'm looking at the spreadsheet and understanding that this does give a breakdown for what types of cases there were fee waivers granted in on like if you go through the different tabs. And so like it doesn't provide that aggregate, but we could figure it out from this data. Does that seem right to you?
Yeah, I think so. If you go through, it shows the number for each type. Yeah, I haven't looked closely to see, you know, generally how many criminal cases are receiving the waivers as opposed to the civil cases. It's not totaled in that way, but yes, we could go through there.
So one last thing that I just flagged for you, Lindsay, as we're trying to figure out the best process, this fee decision could affect like what's the best process for the notice of appeal. Because if there's going to be the fee with the determination by the circuit court, we have to figure out how that's gonna relate to the processing at the justice court. And I know your group will think about that. And on that, if there are folks that want to help Lindsay, like kind of pencil out a process or multiple like processes to propose, contact Krista and she'll get you in touch with Lindsay and you can do that. Jim, I see your window light up.
By mistake then.
Okay, and the other thing Lindsay was going to look into is what OJD has for online filing by self-represented litigants, because this group has been concerned about the ease of access and filing, and if there's online filing available to litigants, that may make it easier to go in one court or the other. That's just something to think about. So let's move to section 10. Section 10 has to do with filing and service of the notice of appeal. And this covers similar information, talks and concerns filing and fee waivers. And so this is falls in the same category of it's the information or the subject that Lindsay's working on. So we can move ahead to section 11. Section 11 concerns the jurisdiction of the circuit court to decide the appeal. And so this section is intended to address when does the circuit court get authority to do anything on the case. And so the first section, Jim has drafted this up to explain that the circuit court gets jurisdiction to exercise judicial authority upon the filing of the notice of appeal, so that it's clear that the circuit court can do things like rule on waivers and other things as soon as the notice is filed. But then subsection 2 points out that the circuit court doesn't get jurisdiction to decide the case on the merits until you have the notice of appeal and service of the notice of appeal. So it's different types of authority that the circuit court gets at different times, depending on what's been done to initiate the appeal. Does anyone have any comments on sections 1 or 2?
Justice Court does have a specific statute on the powers of the appellate court in 157.065.
Okay.
I don't believe I reviewed all the prior notes. I don't believe that chapters 156 or 157 have been discussed, but Justice Court has 2 separate chapters. 157 is appeals and criminal actions and writ of review. Or maybe you have, I don't know.
Well, you know what, we can just put notice on there. I was thinking about it afterwards, because yeah, in the meeting, we talked about notice of the federal blah, blah, blah. I think we can just take the order part out and just say notice. And
all the federal language
I think
is
that
down at the
somebody else
bottom.
is in your meeting here.
So, I mean, we're not
it
referencing,
sounds like somebody's is not muted that.
Right.
yeah, which doesn't make any sense to
That
me,
is.
but I mean, it's certainly not worth
Andy, are you able to?
getting into, because we're not.
Yeah,
if you
I
look at
can-
the document, just because we're signing it and dating it, we're not actually ordering. There's not the court hereby orders that. It's, hey, by the way, federal law says this, so there you go. But I think if we just take out
Wait,
the word.
hey,
order,
Aaron Zemper, I recognize your voice. Aaron Zemper.
you were
I
my
recognize
first
your
phone call on
voice.
this phone. I'm actually sitting.
Aaron. Okay, she muted.
I muted it.
Oh, well,
I
that
was trying to
nice.
figure out who it was, and when I
I
did,
recognized your voice.
Thank you, Sandy. So I Judge, you were saying there's chapter 157.
156 and 157 are proceedings and judgment in criminal actions for judgment for justice courts, and then 157 is appeal and criminal actions and writ of review.
Yeah.
And 157.065 talks about the powers of the appellate court.
Okay. I know we drew from 157.030 for this section. I will check 165 and see if there's anything in that one that's not covered by this. And if there is, we will add it in there. So thank you for catching that. I will double check that.
One more quick thing, when Lindsay is working with circuit court to figure out if pro se's can file electronically, maybe you could ask if municipal and justice courts can file the transcripts electronically. We have the ability to do it, but I mean, we could do it from our end if they could accommodate it.
That would be great. And I know our bill has a provision that that mentions the electronic filing of the record. If the courts agree. So that would be great. It would certainly facilitate things. And I'm seeing some hands up on my screen. Paul Smith.
Does for the first section, does some of the language there depend on what we ultimately decide as to where the notice of appeal is filed? I mean, this says the circuit court has jurisdiction upon the filing of the notice of appeal. It seems like if it's being filed in municipal or justice court, the circuit court, I mean, this is totally technical, but I mean, they don't really get jurisdiction until they know about it, and that's only when it's transferred to the circuit court. So we would want to think about the language there, I think.
Yeah. So
if I may speak to that, that is an issue that caused me originally to propose that the notice of appeal be filed in circuit court rather than in the justice or municipal court. I've since become persuaded for various logistical reasons that it's more practical to have the notice of appeal filed in the justice or municipal court. And it does create a theoretical problem that the circuit court has jurisdiction, but it has nothing in front of it. That's why I would propose that we add a requirement that the appellant serve a copy of the notice of appeal on the circuit court, because then at least the circuit court would have a copy of the notice of appeal, even if it didn't have the justice or municipal court record yet. If we decide not to do that, we're no worse off than we are now, even though there's a theoretical problem of the circuit court having jurisdiction when it doesn't have anything before it yet. That's been the law for decades, and no one has complained that it's a problem. Now, it may be more of a problem on the civil jurisdiction of the justice court, particularly in FED cases, if the tenant is seeking a stay. But on the other hand, once again, I haven't heard anybody point that out as amongst of all the problems that we're trying to deal with, that is not one of them.
And would the circuit court accept a filing like that, which is a copy of the notice, or would they simply say no such cases here and return it?
The current process is that the court does not initiate, the circuit court does not initiate a case until it receives the record. I don't think it has to be that way. That's just the current process.
Until they get the record, not just the notice. And we've got a section talking about the transfer of record, which could put the record 30 days out from the notice filing. So that would be at least a
I think it makes a lot of sense what Jim is saying, to send that over there then, and then make it so that that would create the jurisdiction of the court, because especially if they're the ones that are going to make any decisions on deferment or waiver of fees.
And that would also solve the problem of having a motion to waive or to defer fees filed with the Justice for Municipal Court. The statute could provide that the motion to waive or defer be filed with the circuit court along with a copy of the notice of appeal.
Yeah.
So,
Or frankly, now, I guess, frankly, if we're going to do that, we could just provide that the original notice of appeal and motion to waive or defer fees be filed with the circuit court, and that a copy of the notice of appeal be filed with the Justice for Municipal Court, which would be the signal to the Justice for Municipal Court to send the record over to the circuit court.
that would put the filer in one court, you're saying, and that could be
Yeah.
easier. That would be the circuit court. So,
Yeah.
Okay.
Now, as I said, I somewhat hesitate to say that because the current system where these notices get filed in the Justice Court, where apparently in many courts, they have forms there, the person can simply fill them out on the spot and file them with the Justice for Municipal Court, seems to be working well. So I am loath to fix something that isn't broken, but this is a knotty issue of the circuit court having jurisdiction but not having any paperwork in front of it.
We're opening the case for up to 30 days.
How will the circuit court know if the person made the deadline to file the notice of appeal?
I think Jim, had you suggested that as in like a Court of Appeals case that you file your notice of appeal is accompanied by the judgment, which will have its date on it.
I had proposed that. I don't know whether and to what extent the citations, my understanding is that Justice and Municipal Courts basically rely on the flip side of the violation to record its judgment. But I don't know if that document reflects when it gets entered in the Justice or Municipal Court's case register.
It does not necessarily so reflect that. And in my court, I know we get things entered almost usually it's the same day. Rarely is it later than the next day, but I think the date that most judges, I believe, put on the actual order is the date of the hearing. Not how good a job folks do about the date of entry, I'm not sure. We certainly have that in our system. I assume most courts have that in their system. But Jim, I'm just not sure how, nor am I sure how readily accessible that would be to somebody who's filing the appeal, which again, I think is another reason why filing the actual notice of appeal with the Justice and or Municipal Court is the appropriate and best practice for the benefit of the appellant.
I see. Judge.
And I think I would be fine with that if we were assured that the Justice or Municipal Court was forwarding the paperwork over within a very short period of time, maybe 5 days or something like that. But I understand that many of the courts want 10 to 30 days to do that. And it's that gap of time that bothers me.
And I see, Judge Kidd's, hand is up and it's been up for a while.
My comment is brief, but it relates to Judge Brisbane's comments about 156 and 157. There is really important stuff in those chapters regarding the scope of an appeal, like no appeal from a default sort of stuff. That if we are to eliminate those, I don't see those anywhere in our draft. So I don't want to take us on a cattywampus place here, but that is my concern if those are going to go away.
And we did have an entry in the chat from Jessica who does point out that section 14 of the work draft reflects part of 157.065. So at least it looks like part of 157.065 is there. And certainly we will want to keep an eye and make sure that everything that is currently there is acknowledged in the draft, including when we get to what types of local court orders are appealable, which is starting at section 15 and beyond. So this, when we're figuring out this jurisdiction question, it's going to depend on where the notice is filed. And it seems like there's good arguments for both places on that. And maybe we'll write up those processes and the pros and cons on those. But I'm not hearing a consensus about where the filing is.
Could I talk back to one of Jim's comments just for clarification? In Clackamas County, the circuit court has agreed to fast track civil appeals. The violation appeals are on a slower process, not that much slower, but they're not taken with such urgency. So, for example, an eviction appeal would be heard within 2 weeks or less. And violation appeals are treated more like a regular civil case as far as the length of time, maybe a month or two sometimes, because different people have to be notified.
What is the practice of your court in forwarding the record to the circuit court? Does it differ from let's say in violation or misdemeanor cases on one hand and FED or other civil cases on the other?
Well, not really. We try to get it over there as soon as possible, but I know if somebody's out or sick or out of town or something, there might be a longer delay on the violations. The civil cases, evictions and other civil appeals get priority because we know circuit court will take those quicker as well.
Can move.
Justice Duncan, one other thought I had is that although those of us who deal with appeals from circuit court are used to the rule that it's the date of entry of the judgment in the register that triggers the running of the 30 days. I'm thinking that because the register is not really an important part of the justice or municipal court system in terms of whether the public has access to it, that maybe the better rule is to go 30 days from the date that the judge signs the judgment. That's something that the defendant presumably has, and it's an easy date for the defendant to look at and for the circuit court to look at when if and when it receives a copy of the judgment.
For our local court judges, when the defendant is dead in one of these cases, are they getting a written document that will have the date of the judgment or order on it? Like, will they have that in hand?
Not every case gets a written judgment. Sometimes the judgment is an entry into our magic system. The majority are. Now, if somebody wants a judgment, if I get the sense that they're appealing, then I'll write out a judgment for them so they've got a document. But not every case gets it as a matter of course here.
In my court, they would request it at the window if they wanted to have a copy of the written document, which obviously if they're going to pursue an appeal, they would want to have that.
And
I still think sticking with the normal, 30 days from entry of the judgment is the way to go. It gives if anything, it gives the appellant, if there is any delay in entering, it gives the appellant a little break in that sense, in terms of their deadline. But it's just for the sake of consistency with other types of appeals throughout the Oregon revised statutes. I think there's just makes sense not to carve it out as something unique in that regard. It is, and Jim's right, and because as I pointed out, every court is required by statute to keep, the log and the case log and history and entry of all these things. It's just all I meant to indicate was it's not a defendant would have to actually request that record kind of separately. So it's possible, but and also not all justice courts or municipal courts are full-time courts, and so it's not you don't have that everyday access to to looking those things up. Our court's full-time. I know that I think Judge Brisbon's court's full-time, Justice Kidd's court's full-time, but lots of justice courts are not, lots of municipal courts are not. So
Do you ever have situations where you hold a hearing or a trial and you take the case under advisement and decide it later, or do you always decide from the bench?
I almost always decide from the bench. There are a few times I've taken cases under advisement. The ones that I've done that with have tended to be small claims cases. But it's probably 1 or 2 a year. I like to give people an answer while they're there, unless it's just not possible to do so. I don't know how other folks do it, but that's me.
I agree. I think the majority of judges make a decision right then.
Okay. But we will need to make sure that section 1 reflects whatever our decision is as far as it accounts for wherever the notice of appeal is filed. And count for section 2 talks about when the court can decide the merits of it. Section 3 says no court can extend the time for filing or service. That's consistent with current law. Sections 4 and 5 talk about service, and that service on certain parties is not jurisdictional. So that's 4 and 5. Last time we met, we talked about service, and we talked about adding the citing officers as people who needed to be served. So if we do that, then section 5 would need to be amended to accommodate, to explain that service on those officers was not jurisdictional. And the thinking of serving those officers, that would be an additional requirement on any appellant. And I wanted to check and see for the prosecutors who, I don't know if we have any on the line, the prosecutors who pick these cases up and need to know about them going into the circuit court. Is the current notice, is the current service process sufficient? What's the thinking behind adding the citing officers? It'll be an additional burden. We don't require it now. What's the thinking there?
I think the citing officer should be added because in many courts, a citing officer is presenting the case to the circuit court and to the justice court. The DA doesn't get involved very often in violation cases. Well, they can't unless there's an attorney. So the citing officer is actually most often the person that should be notified, not the county attorney or the district attorney. The district attorney just throws these away. They don't even keep them.
On appeal?
Right. The only time the district attorney would get involved is if the citing officer needs to consult with them or ask them to help out with the trial at circuit court.
Yeah, and so this would be, right now the law, it requires service on the DA or the.
The
county.
DA or the county attorney if it's an
Yeah.
ordinance violation.
Yeah, and so I was wondering, I'm not seeing on the screen any of our DA or county attorney folks. But I'm wondering if there's a problem with them getting notice right now, which we're remedying by serving the citing officers, or
Oh,
at this stage.
yeah, I don't know the answer to that.
Okay.
But
So-
I believe our court clerk's going to instruct the person to cite the citing officer's agency. Because the district attorney is not going to get involved at all.
Do they have to handle the case on an appeal though?
They do present the case on appeal as well.
I think that's why they get the service of the notice of appeal.
They should,
Yeah, okay.
I think you're talking about two different days.
maybe.
Oh.
some-
Mhm. The officer handles the appeal all the way through. The
The
DA
case
never gets involved.
handles the case all the way through from the justice court through the circuit court.
As long as the defendant's pro se.
And sometimes when the defendant is also represented by an attorney.
In
That's
this-
true. That's true. There are certain places that the statute authorizes the DA to prosecute the case if the defendant has an attorney, but does not require it.
Yeah.
And many times when I was in private practice, when I would go to a smaller court, smaller municipal court, in particular, there would be no city attorney on behalf of the government. It would simply be the citing officer and myself.
In the circuit court.
No, that in the trial court and then in the municipal court.
Right.
In
then
both courts, Dan, I think Judge Cross in both courts, right?
But no, well, then if you appealed, well, in my experience, anyway, if you appealed from the municipal court where you didn't have a prosecutor, then the DA would get involved potentially if you went to circuit court, if the defendant had a lawyer.
It varies from county to county. In Clackamas County, the officer handles it all the way through, even if there's a defense attorney on the other side.
I agree, it varies, absolutely. So
Jordan and Heather.
So I was just gonna say, I have no experience directly with this from the prosecution side of things, but from the prosecutors that I've talked to and from when I was handling some of these appeals, they would get the notice and then forward it on to the police, the officer, if they didn't want to do anything with it. They handled that pretty routinely. They may have complained that it was mildly inconvenient for them, but they did it. And I don't think it was a huge problem. I certainly never won a case because the officer didn't show up because they never got notice, but.
So maybe we
You're up on that.
change.
I think
Should we,
Heather. What's your hand up?
I'm wondering, given the variation across jurisdictions, like I know, this is municipal court, but here in Eugene, if you're represented, then the city prosecutor will handle the case. But I think if they're unrepresented, then it's an officer. I don't know about on appeal. On appeal, it'd be the city prosecutor and the represented party's attorney. But I'm wondering, given the variation, what would be the issue with just having service be on the attorney representing the entity that's bringing the charge? And then allowing that attorney who's representing them to then pass it along to whoever the right person is to deal with it. I'm just thinking that this is going to be confusing for folks to be serving multiple government entities and creating more barriers to appeals from the perspective of a pro se litigant.
I think in answer to that, the way that most appeals fall apart in Marion County is the officer somehow doesn't get notice or doesn't get notice from the trial or something, right? So we get an inordinate number of FTAs at the circuit court in traffic, right? So I think making the process more complicated from the government side is not a super idea. I don't think it serves justice that way. I would say if they're going to serve one entity. It should be the office of the citing agency, right? So we don't have to worry about tracking down the person, right? Just go to the office of the sheriff or whatever, because the vast majority, like I've done 50,000 cases have come through the court since I've been a judge, and I've never once had a DA, right? Because it's almost entirely a layperson court.
The
How
other
many-
thing to consider
How many
is
citing agencies? Sorry,
over 40 agencies cite to this court. So the DA would be burdened to have to figure out how to contact various different agencies.
the flip side of that though is the DA is probably in a better position to figure that out than a lay appellate.
That was my thinking too, just that if there are 40 agencies, who as just the typical person, you know, navigating the system, that's a lot to sort through.
Right, but they just went
Well-
through a trial with, like, literally with the officer right there. They know
Right.
what the citing agency is.
Right. That's who presented the case at the trial they had. So it could be the sheriff, it could be state police, it could be local police. They were there in court with them, so they'd know who it is.
I'm not sure that leap is correct. I mean, even as a newer attorney, I had trouble figuring out which agency officers were that I was dealing with, and I was only dealing with like 4.
I would just to kind of underscore that point, from speaking with my clients preparing for various proceedings, even when they recall who they were interacting with, there's often a lot of confusion around what agency that person represented.
It's on their citation. Just so you know.
It's
We
supposed to
know,
be. It's not
but-
always that legible. I will certainly say. But if there is a problem, that's where if the notice is being filed in the circuit, in the justice court or municipal court, we're going to be helpful with the folks in making sure that they get that information on there. And that's information that the court will have.
That's what I was thinking, that perhaps each circuit each justice or municipal court would have a sheet of paper with all the agencies that court could handle, and the judge just checks off which one it was in this case and hands it to the person, so they know not only which agency they serve, but also what address, because figuring out which address to serve may be an additional issue.
That's a good idea. The clerk could give it to the appellant.
Yeah, and we have hands up too. You see, Mr. Powell and Heather Barrett.
Yeah, I was gonna, and again, this is from my perspective in Klamath County, which is a relatively small jurisdiction. When we do appeals, we notify the officers. Our district attorney's office is currently way understaffed and wouldn't even pay attention to the notices. They would get them electronically, but they wouldn't pay attention. We work the appeals from our justice administration work just like we work our traffic docket. So we would notice the officers. Again, much smaller scale, so it's easy for our clerk staff to do those kind of things, which
Okay.
would probably not be the same in Marion County.
Okay. Heather.
I had a clarifying question, which is something I could look up, but maybe someone can just answer it for me more quickly, which was around what the status quo is. Like, am I understanding correctly that currently these agencies are not the ones to be served, and this would just be creating like a new service requirement? Is that right?
That's right. Currently the service under the statutes is on the district attorney or the county attorney. So this would be a change in the law. So.
Or it could be both.
I think it could be both, requiring both of those. Right.
Yeah.
Right. I think the suggestion was to add service on the officers. So I think to Heather's question, yes, it will be.
And the thing came up in the box I saw rather quickly about some question about different stations or places that you might be addressed to. In my experience, at least in Washington County, each law enforcement agency has essentially a court coordinator. And that's the address that we would use and that we would give out to anybody would be to that person, because quite frankly, it's the individual officer is not going to know what to do with that except give it to the court coordinator. And so, that's as a practical point. That's where you want to go, where whatever address you have as your contact person, point person for court appearances for that agency. That's the address you want to use for that notice of appeal.
That was my message. I was just saying, I agree. It's a good idea to hand out a specific address.
So, and again, the local courts are the ones that certainly know that information right away.
I frankly was thinking of not adding service, but providing for service only on the citing officer of the office of the citing officer, and leave it up to the citing officer or that officer's agency to decide whether to refer the notice of appeal to the DA or county council or city.
The problem with that, I think, Jim, is that there are cases where attorneys are involved. If that's where I have cases, one day a month, I have DA day in my court. So where we have the Washington County Deputy District Attorney prosecuting cases, because those are cases where the defendant has counsel. Or if I have a code enforcement case where the defendant has an attorney, then somebody from county council, an attorney from county council is here to prosecute the matter. So I don't think we should just replace it with the officer, because we do have cases where we do have county council or the DA's office as the attorney of record for the state.
So maybe we can just summarize the issues here, which is there's a concern about putting an additional service requirement on people that doesn't exist under the current law, which may be difficult given the number of agencies where addresses are available. That's a concern. Another concern is that if it remains with just the service on the prosecuting entity, which may not have appeared in the justice court or municipal court, the proper people who might handle the appeal on in the circuit court, which I'm understanding in some jurisdictions could be the officers themselves, might not get notice. So we've got those competing concerns. That's where we're at. Okay. And then I see Lindsay will take your comment, and then we will talk about what is coming up next.
Oh, I just wanted to note that in chapter 153 that governs violation proceedings, 153.076 sub 6 does say the court shall ensure the district attorney or city attorney is given timely notice if defense counsel is to appear at trial. So there's a provision in the just regular violation proceedings for the circuit court to notice the district attorney in those situations.
Okay.
Justice courts are also required to let the DA's office know if an attorney is appearing on behalf of a defendant.
Okay. I appreciate everybody's input. I'm sorry I had us getting through many more sections today than we did. We will, what I would like to do at our next meeting is circle back to some of the things that we have touched on. We're getting more information on, or groups have been meeting. And so I will send out an agenda to that effect. It is going to include, there was a subgroup that talked about jurisdiction. Jim was heading that, and there were a number of people involved in that. So we'll hear from them. Jim did work on the contents of the notice of appeal and sample notices of appeal. I'd like to take those up. We'll hear from Lindsay on the notice of appeal fee process, how to handle the fee waivers. And maybe it'll be alternate proposals, like here's what it would look like if we are filing in the circuit court. Here's what it would look like if we're filing in the the local court, I think there's been a good discussion of the pros and cons of both of those, and we see them coming up and up again relating to, like we just saw on the jurisdiction of the appellate court. And then that'll have us circle back on the things we've talked about. I would say we are making progress on this, just the proceedings. I hesitate to say things will go faster with the next ones, but I do think they will. We're talking about the transfer of the record. The big things that lie ahead are really after section 15. We're going to be talking about what types of cases are appealable. And so keep those on your radar. Go ahead and look. We are talking about, are there things that are appealable? Default judgments, Judge Kidd. How do we make the laws as clear as possible about what is appealable and what is not appealable? So that is probably a meeting or two out, but just take a look at that, think about that. And yes.
Just a second. I was wondering whether it might be helpful if someone would contact all of the DA, city prosecutor, county council members and ask them to confer on this issue of service and ask them what would they like? What do they think is the best solution?
I maybe I'm gonna volunteer Krista here. Krista and Sandy, maybe you can work together to reach out to those folks, because I think they do have they will have valuable input on who needs to be served and how they're currently handling this service.
Yeah, I could definitely try to help if you let me know who I need to contact.
We do have some representatives in this work group. I don't believe they're here today though, so.
Yeah, we have Melissa France in Lane County and some other folks, but yes, great. I do think so. All right.
Bill Golden's one of the individuals that's in the DA's office here that's on this committee.
That's right. That's right. Okay. That's all that I have for today. Thank you, everyone. As always, appreciate your good thoughts and insights and work on this group. Have a great rest of your day, and we'll see you at our next meeting.